All right, everyone, thank you so much for taking your seats. We're going to start panel one here in a minute. We'll begin our first panel, A Better Fair Housing Act, Evaluations and Recommendations, which will be moderated by Professor Matthews, who is Assistant Clinical Professor of Law at Suffolk University. And we hope you enjoy our panel. Thank you.
Thank you. So my name is James Matthews, and I'm an assistant clinical professor at Suffolk University Law School and also a faculty director of our Accelerator to Practice program. And I teach and supervise students in a clinical practice that works very closely with our housing discrimination testing program to support representing clients who are victims of discrimination. And I have the distinct pleasure of introducing our first panel of housing law experts and scholars who will be exploring different aspects of the Fair Housing Act, revealing some distinct ways in which the Act could be more effectively employed or reimagined altogether to better protect people from discrimination and create more equitable communities. First, we'll hear from Professor Melvin Kelly, who is an associate professor of law and business at Northeastern University. Professor Kelly's research focuses on the socio-political, geospatial, and civil rights implications of decentralizing public authority. He also writes about anti-discrimination jurisprudence governing real estate transactions, as well as community economic development tactics. Professor Kelly will be talking about geography and sovereignty in the digital age, and how the potential procedural implications of the Federal Fair Housing Act may provide for greater opportunities for the participation of marginalized populations in formulating policies and practices that can lead to more just cities. Next, we'll hear from Professor Rigel Oliveri, who's a professor at the University of Missouri School of Law. Her scholarship focuses on housing discrimination, zoning, and property rights, as well as sexual harassment. Professor Oliveri will address several recent proposed amendments to the Fair Housing Act, focusing on their efficacy in addressing sexual harassment in housing, and provide some of her own recommendations for how the Act might be revised to better combat sexual harassment in housing. And lastly, Stacy Schexnayder, who's a professor at the Tulane School of Law. Her research and writing on housing law and policy have been influential in federal civil rights litigation, and in fact, her work was cited by the U.S. Supreme Court in Inclusive Communities, a seminal decision which confirmed that disparate impact claims are cognizable under the Fair Housing Act, preserving an important tool for combating policies. Professor Schexnayder will be discussing the disparate impact standard under the Fair Housing Act. It's a great example of scholarship in action, so thank you all for your work. And I'll hand it over to Professor Kelly.
Should I remain seated? What am I doing?
Either, yeah.
I got options. All right, fair enough, fair enough. I suppose I'm comfy, and I'll hang in a cord for the moment. I'm working on this project, and it's tentatively entitled "Revisiting Geography and Sovereignty in the Digital Age." And so, in particular, I'm kind of concerned here with sort of our state of affairs as we're approaching this kind of new chapter in what it looks like with respect to fair housing advocacy. And so we've already, as a community, brought several successful lawsuits sort of challenging the use of property technology by landlords who utilize automated screening tools to evaluate prospective tenants, which have been found to replicate discriminatory practices, right? And so while these substantive interventions are laudatory, this essay is arguing that these steps don't go quite far enough, and that there's been insufficient attention to the potential procedural implications of the Federal Fair Housing Act as a source of ex ante remediation. And so in building some of these contentions, I pay homage to some contributions from Professor Richard Thompson Ford, right? So, you know, insofar as its current incarnation, Federal Fair Housing Act, you know, has a list of protected traits, right, that can't be taken into account: race, color, national origin, sex, disability status. We've also sort of seen recent developments with respect to Title VII, which are likely to reverberate here in Title VIII, in the ways in which there might be protections as well for the LGBTQI plus community, right? And that are grounds for causes of action under the FHA. What does that look like? Well, we have a ban on disparate treatment. We have discriminatory effects theories. We also have an obligation with respect to the federal government and its grantees under its programs to affirmatively further fair housing. And I'll talk a little bit about these in a bit more depth, but one of the questions that we have at the onset is sort of, what does this mean as a practical matter, right? What does all the foregoing mean insofar as outlawing discrimination? And so on this front, Professor Ford has argued that we should recast the light of the civil rights legislation during the 1960s as effectively erecting duties of care, right? Duties of care that are mediated through the bans, for example, on race-based discrimination. And so these obligations are conceptually akin to social responsibilities to avoid causing nuisances or committing torts, right? The sort of the same kind of framework is undergirded in civil rights and anti-discrimination doctrine. And so what this means is that they effectively entail adherence to a standard of conduct that individuals and institutions must adhere to, right, to avoid the prospect for liability, right? And unfortunately, this sort of reality is obscured because we have debates about intent and causation. But at bottom, what we're talking about is effectively a duty of care and exactly, sort of what steps and processes individuals and institutions must adhere to in order to ensure that they are not liable for perpetuating systems of hierarchy and segregation and the like, right? And so from this perch, what I'm suggesting is that we can begin to appreciate the process orientation that the FHA encodes and enforces. So what do I mean by this, right? Well, first let's look at the discrimination. But as we know, it's sort of sufficiently capacious to capture implicit bias, unconscious discrimination, and so forth, right? But when we're looking at this idea of folks being treated differently because of a protected characteristic or trait, one thing to note is that, the FHA has exemptions, right? And so there are certain, owner-occupied home, 4 or less, certain transactions with respect to single-family units. These persons are exempt from the Fair Housing Act, right? But they are still not allowed to make statements. So in effect, right, these persons can engage in discriminatory conduct, they just can't communicate, advertise, or say that, right? And so what does that mean? Well, effectively, what I'm trying to suggest is that that's sort of a process or a procedural kind of regulation, right? They are free to engage in that behavior as long as their process doesn't entail sort of explicit communications of the discriminatory animus that may, in fact, be motivating their engagement with prospective tenants. Now, as you've heard a little bit about already so far, in this day and age, right, because we have these laws, it's unlikely that folks are going to advertise their discriminatory animus, right, their unlawful bias. And so how do we get at that? A primary technique is testing, right, where we have that protected class tester and the control tester, and then we evaluate their experiences. And so ultimately, right, at this juncture, we still don't know, kind of definitively with respect to that person's state of mind, and in some respects, they might not be tuned into that as well if it's a question of implicit or unconscious bias, right? But in any event, the deviations with respect to the procedure that we're able to kind of capture through the testing allows us to make these inferences of unlawful discrimination, right? So again, and procedure of actors in order to discern whether there is in fact discriminatory animus, right? And so just a couple of more examples on this front to sort of push in the direction that I'm going. So with respect to staring, right, there was a recent case on December 13th, 2022. There was a consent decree that was entered into a case called United States v. Housing Authority of Ashland. And basically, the allegations from the U.S. DOJ are that the housing authority, as well as there were some private owners and an agent of low-income housing, they were implicated in this pattern or practice of discrimination through steering and assignments, right? And effectively, replicated segregated housing patterns at the properties at their site. As far as making out this allegation, they were able to do this by noting the degree of racial disparities at the 5 communities. They were statistically significant and couldn't be explained by non-racial factors. And so the tenant records, tenant move-in records, other data showed that from at least 2012 to 2018, that the housing authority had assigned black applicants to disproportionately black communities, white applicants to disproportionately white communities, in a manner that departed substantially from what would have entailed a neutral, non-discriminatory norm, right? So the basis of that comparison was to think about this hypothetical procedure that didn't invoke these racialized considerations. If they had adhered to a neutral process, there was no way that these statistical anomalies could be explained, indicating that there were dual communities, as it were, right? Another example is that when we look at the zoning situations, right? When we argue that there are land use that may have discriminatory intent, we often are looking at the process and the procedure. And in one case, I looked at, which is Avenue 6E Investments LLC v. City of Yuma, Arizona. The real estate developers brought claims alleging a violation of the FHA on the basis of disparate treatment as it related to the Latinx population in the area. And the court held that the developers there had plausibly alleged that their denial of their zoning application to have basically denser development at the site in question, they concluded that there was enough here with respect to the departure from the city's standard procedures to suggest discriminatory animus, right? And they had moved in a way in which their experts had made suggestions, and they had disregarded those suggestions, and it became anomalous to explain, right? So again, at each of these junctures, what I'm suggesting is that we are attuned to the process and the procedure in order to understand and appreciate the Fair Housing Act. And this sort of accords with Professor Ford's observation about what anti-discrimination doctrine is doing with respect to erecting a duty of care, right? But this procedural aspect is also embedded in discriminatory effects claims. Basically, housing providers are kind of tasked with trying to identify the least discriminatory means of effectuating their policies with respect to tenant screening, insurance, financing, or the like, right? Unless otherwise a plaintiff could demonstrate that they have fallen short by identifying an alternative process that would have been less harmful but still allowed that housing provider to meet those aims and objectives, right? So why is this helpful? Well, if we move, it points a path to thinking about a political dimension that the FHA is designed to address and remediate. Now, we can already see that there is an economic implication, right? And how do we know that there's an economic implication, especially as it relates to race as a protected class under the FHA? Well, we have these debates that are centered around spatial justice visions that are predicated on the siting and location and availability of affordable housing. And yet, class is not a protected status under the FHA. So this is an implicit recognition that race, right, is a construct that facilitates access to economic and political power, right? And so these intergenerational repercussions are still with us today. And so there's some irony here with respect to our constitutional jurisprudence that has been noted insofar as the ways in which we have made suspect attempts to carve out via districting, rerouting political power to historically marginalized communities, but we allow historically exclusionary communities to employ zoning powers without much way of additional intervention. But this is something that we need to think about and rectify, and again, we can do so by virtue of highlighting this political dimension. And is sort of undergirded by this idea of having autonomy and agency, right, and the ability to have input in the decisions that shape housing in your community. Part of this we see insofar as how the nation's first Fair Housing Act, the 1866 Act, was initially or was eventually construed to have implications in the private sector, in this case called Jones v. Alfred H. Mayer Co., which suggested and indeed held that Congress had the authority to eliminate these badges at incidents of slavery. And so this development, in conjunction with the deep-seated history of exclusionary municipal incorporation, as well as other forms of disenfranchisement, indicate that the FHA should offer heightened protection for the participation of marginalized populations in formulating public policies and practices that shape access to housing opportunities in their communities, right? And there's this renewed urgency for innovative interventions as we transition into this new chapter in fair housing advocacy in the era of platform real estate, right? In which prop tech, under the guise of objectivity, neutrality, are replicating these discriminatory practices, limiting access to information for others, empowering already privileged persons, subjecting protected populations to different terms and conditions, effectuating automated denials of access to housing opportunities. And yet, while this development is concerning, it's helpful to remember that the term algorithm actually predates computers by 1,000 years, right? It's this idea of logic and control, right? And if we look at that lens, then that framing helps illuminate that algorithmic governance is just the latest tool for entrenching a regime of racial capitalism. And so if we fighting these new iterations as methodologies evolve, or we can try to find a way to get ahead of these problems. And so a starting point for that is that, you know, the AFA, the current envisioned AFFH rule, affirmatively furthering fair housing rule, this is sort of why it incorporates a mandate for community engagement, right? It recognizes that there's been a way in which populations have been foreclosed from having access and input into these decisions. And so that might be a useful starting point to build this out, but tactically, we need to be mindful, particularly in the demise of Chevron deference. We need to move in a way that's going to give the affirmatively furthering fair housing provision meaning independent of the regulatory regime. And so some of my colleagues have suggested that it's too amorphous of a concept, but my technique or my tactic, or what I would propose, is that we can begin to give that idea meaning by virtue of looking at the ways in which parties that have been found guilty of violations insofar as running afoul of the Fair Housing Act have been ordered to take various actions. If I tell you, right, that you have violated the law and this is what you must do to rectify the harm, then those are indications of what a party who has the obligation to AFFH, affirmatively fair housing, should be continuously on task with doing. And so my last example, and I'll end on this front, is just that Recently, there was the Lewis v. Safefront Solutions LLC case that settled on December 22nd, 2023. And this was a situation in which there were allegations that SafeRent, which was a tool that was employed by landlords, had calculations using a formula that resulted in the disproportionate denial of rental housing for those applicants that were Black and Latinx, with to pay their rent. And so as part of the settlement agreement, SafeRite agreed that if it ever wanted to offer a tenant screening score that could be applied to voucher users, it would only do so after validating the score by agreed upon third party. And at this moment, it was chosen that the National Fair Housing Alliance would review it on the front end before it was unveiled. And so as fair housing advocates, I'm suggesting that we need to contemplate pathways to slowly but intentionally build this process as the norm, right? And thereby politically empower protected populations under the Fair Housing Act. All right, thank you.
Thank you very much, Professor Kelly, for that talk. I should have mentioned the ground rules at the beginning. We're going to have each panelist present, and then we'll have time for about 15 minutes of questions at the end. Thank you.
All right, hi everyone. My name's Rigel Oliveri. I'm a, excuse me, I teach law at the University of Missouri School of Law, but I also want to highlight one other piece of my background, which was that I used to be a trial attorney for the U.S. Department of Justice Civil Rights Division in the Housing and Civil Enforcement section. And the reason why I want to bring that up is because my work there directly led to a lot of the work that I'm doing now as an academic, and has direct bearing on the piece that I'm going to be talking about today and the issue that I'm going to be talking about today. A lot of times when I think my list of scholarly interests is said aloud, there's one in there that doesn't sound like the other. I'm interested in housing and zoning and property and sexual harassment. But in fact, when I was an attorney, I went to DOJ thinking I was going to be doing and I did, but fully half of my docket there was actually dealing with cases of sexual harassment in housing, where landlords were abusing, sexually harassing, and sexually extorting their female tenants. I didn't know that that happened until I started working there, and I still think that it is a completely underreported and understudied phenomena, but it is an extremely serious one, and I think it's a prevalent one that if we're going to be talking about housing in the 21st century, we have to start dealing with and looking at solutions for. So to begin, this is the title of my presentation, there have been exactly 5 empirical studies about the nature of this problem. There's been a lot of good law review articles about sort of theoretical perspectives for dealing with this. There has been almost no actual hard research. And even the pieces that I have here, one of which is my own, aren't really rigorous clinical studies, quantitative analysis type things. They're more, anecdotal studies or reviewing a small sample or things like that. So we just don't know enough about it, and I think we need to know more from the get-go. What we do know, and I'll put that in quotes because this just comes from those studies, victims are overwhelmingly likely to be female and poor. This is something that happens to poor women, not to women who have the means to get out of situations like this or not be in them in the first place. And I'll talk about that a little more. Of course, there's all the intersectionality that goes along with that. Victims are more likely to be women of color, have disabilities, be caring for small children, or relatives or things like that. So there's usually multiple pressures on them that lead to the situation being as bad as it is. The few studies that we have that talk about prevalence, one of which is mine, I did a study sampled at a housing authority and asked had they ever experienced behavior that would meet the legal definition of sexual harassment in housing, 10% said they had. I think that's probably a low number. I was doing it in my local little housing authority in kind of a small town. I bet if I did it somewhere else, it'd be larger. Another researcher issued a similar study. She got a 25% positive response rate. So I'm guessing that it's anywhere between 10 and 25% of low-income women have experienced this behavior at some point in their lives. In 2019, DOJ and HUD announced an initiative that they were going to start aggressively enforcing sexual harassment in housing. They'd always been enforcing it, but they were going to have kind of a renewed push. And that was also going to include sort of a public awareness campaign, meetings in areas all around the country where they would meet with lawyers and service providers to try to get awareness out there that this is a problem and it needs to get reported and how that should take place. So I think this is a very welcome development, and I would like to offer some suggestions for them to make it more effective. But what it also did, this new initiative for enforcement, was it meant that there's like a nice big fat data set to take a look at, and that is the DOJ's cases. Some of these are my cases from way back when I was a lawyer. Most of them are new, though. Fully 43% of all of DOJ's civil rights cases have been filed in 2019 or later. So now there's a big trove of information on the DOJ's website. They file every complaint, and consent decree and other information are all contained on their website. So I thought, let's look at that and see if we can learn things about who these defendants are, who the women are, what the conduct looks like, what happens when women try to complain, and maybe use that information to tailor our responses. This is 76 cases were on there at the time I started this study. But I obviously had to cut it off at some point. Most of them had already been resolved through some kind of consent decree, so I could also look at how much the settlements were for and things like that. And kind of the number of victims involved. There was sort of a lot of information contained in the settlement agreements as well. But some of it was just coming from a complaint, but I think the complaints were pretty detailed and useful sources of information. So, questions I ask myself. Who's the perpetrator? Who is it that is actually doing this? There were 83 total perpetrators in the 76 cases because some cases had more than one bad actor. And here's the thing that I think is really salient and important about this. 3/4 of them were independent owner-operators of their properties, meaning they were the person that owned it and they were the person that ran it. To some extent, sometimes people ran it with family members, often spouses. Sometimes it was, parents or things like that. But my point is, these are people who are the only person who is the point of contact for the tenants. So they are also people that have no one looking over their shoulder. There's no management apparatus above them or around them. There's no one else for a tenant to complain to if they are having a problem. So these are individuals who are able to operate almost completely without any kind of oversight. Of the remaining, 27% that were not owner-operators, it was still pretty amazing that, they were arm's length employees, but the perpetrator was still maybe the only person that was hired to manage an apartment complex and was kind of left to his own devices to do whatever he wanted. So these were still employees that didn't seem to have very much oversight. Only 12 out of the 83 worked for some sort of an organization, either a housing authority or a property management company that did provide some level of oversight. So I think that's an important detail. What kind of housing? It was tricky because I could definitely tell when the cases involved private rental housing. What was less clear was whether and how much of that housing was being paid for through a housing choice voucher or was in a low-income housing tax credit property. Those details just often weren't in the complaints. They might be, but it was sporadic. Definitely some of them were. But definitely a lot of them were just in private housing that was not being served by any kind of government voucher program or affordable housing program. You know, and that actually makes sense, because the vast majority of low-income people who are poor enough to qualify to live in such housing don't get it. Only 25% of people who are poor enough to live in such housing or to get a voucher actually receive one because of resource constraints. So I know most of this seems to be happening in private rental housing, whether being paid for by a voucher or not. Where it doesn't seem to be happening as much is in public housing. And I think in our popular discourse, people often associate public housing as being the only kind of housing that poor people live in. That's certainly not true. Housing choice vouchers are much more common. But I think people are also very sort of reflexively blame public housing for being terrible and having all the problems. It actually looks like public housing, while it certainly does have instances where harassment takes place, isn't where we're most concerned. Some of that may be because there is a management structure and an apparatus, and people can't just get away with anything there. Okay, I'm gonna move quickly. What is the harassing conduct that we see? In so many of the cases, in 71% of the cases, the harassing conduct consisted of explicit demands or requests or threats to exchange sex for rent. The landlord says, I know you're poor, I know you can't afford to live here, you can stay here if you do this with me. In many other cases, the conduct also involved conduct that I would coerced sex, touching and grabbing, indecent exposure. In 19 of the cases, children were either victims or present witnesses of the behavior. What did the victims do when this happened? They did what a lot of people do. They called the police. 14 of the victims who complained to somebody outside of their housing system, 14 of them called the police. Only 2 of those cases involved the police actually taking action. And in fact, 7 victims who obtained orders of protection, that was a bad idea because that resulted in 6 of them getting evicted from their housing. The 7 of them who complained to other people who were involved in the housing were complaining to things like the perpetrator's wife or the perpetrator's mother, who also took no action. So there's a clear lack of complaint mechanism here that for victims to even know where to go. All right, I'm gonna wrap it up so I don't talk for too long, but what can we take from this? What do we do with some of this information? Well, I mean, I think it's interesting. There's been sort of a constant bill that keeps getting proposed in Congress and not going anywhere, which is called the Combat Sexual Harassment in Housing Act. And it uses sort of the language of the law, of legal cases and the legal framework for satisfying the definition of severe or pervasive hostile environment sexual harassment to say these kinds of behaviors, many of these should be considered, discriminatory housing practices. I think that's fine. I think that's good. I'm happy for that. It's a response to earlier cases where some courts weren't finding this kind of behavior to be sufficiently severe or pervasive to constitute a hostile environment. I think courts are mostly on board with that now, and I don't know that it's too much of a problem, but this certainly would help. I did find, though, there's one iteration of this bill that keeps getting proposed from 2016 where they put in one other violation of the Fair Housing Act for any landlord to request sexual favors from a tenant. I think that's pretty important because what I think we see from this data and from all the anecdotal evidence that we can see is that this kind of situation is something that arises because landlords are using their access to housing, their control of access, to exploit and extort sexual favors from their tenants. That is the business model that they seem to operate under, and many of them don't seem to recognize what they're doing as being something that's against the law. We clearly know things like rape, forcible touching, and things like that are, but many of the landlords actually seem to present themselves as this is just a business proposition. And I think that really gets to the heart of what's wrong with all of this, is that because we have this unregulated group of people who are controlling a very basic resource, right? Think of any other aspect of our economy where control of that rests in the hands of a completely unregulated person, right? When I buy gas, I don't have to negotiate at the gas station for whether I can get that, you know, by using money or something else. When I buy food, when you get medical care, when you get any of the other things that you get in life, this isn't something that's happening. It's happening in low-income housing at what appears to be a reasonably large scale. And so I think this piece of this law, which has never, or bill, has never shown up since. It showed up in the 2016 iteration of this, but then it went away. I think it needs to come back because I think we really need to underline that this is what's happening. This is a transactional thing that landlords appear to think, some landlords appear to think can be part of the way they do business. And if we make that very clear, we take the legalese out of it and just say it is unlawful to make a proposition like this to your low-income tenant, that might go a long way. Other things that I can think of that I'd like to suggest for HUD and DOJ to do when they're out doing these public awareness campaigns might be to include lawyers in their meetings, because it looks like victims are calling the cops and it looks like cops are not doing anything. Perhaps local prosecutors should also be brought into the fold here, and perhaps we should start dealing with these as the criminal violations, many of them are. I'm reminded of how, 30 years ago, domestic violence complaints weren't usually taken terribly seriously, and there wasn't police and prosecutorial responses, and now there are, at least it's better. So I'm wondering if this is the kind of thing we can bring along with awareness. And then finally, again, local actions. We talked about federal government can't do a lot of stuff to affect local conditions on the ground at least as effectively as municipalities and other local governments can. And that's where I'm a little hung up, because I'm not quite sure what the lever is to pull to get local governments to regulate this conduct in some way, to provide oversight for all the small, mom and pop landlords who are basically operating with very little regulation. I think the mechanism for oversight has to live there. I'm not quite sure how it would look and how to incentivize it, but I think that definitely needs to be done. So I think I'm about out of my time, so thank you very much.
All right, good morning, everyone. How many students do we have in the audience? A lot. So just so you know, my Civ Pro students right now are taking a midterm. And I'm here with you, and my phone is not with me, so they can't call me with any problem. It's a practice exam, so it's okay. So I'm going to talk about disparate impact theory, and this is sort of like, when will she stop talking about disparate impact? But here I am again. This is an incredibly important theory, and the way I'm looking at it now is that it's through this lens. So you may know that in 2015, the Supreme Court recognized disparate impact theory under the Fair Housing Act as an available form of liability. This was not inevitable. Many people thought that we would not get that outcome, but the court did decide to uphold disparate impact. It's a very contested theory. It remains contested. And we have a colleague who sort of makes comments about, well, we'll see how long we have it. And I'm not quite ready to concede anything on that. But I do think that we need to think about disparate impact from a no permanent victory standpoint. And what I've been thinking about lately are, what is some of the language and what are some of the tools that are more likely to resonate with the current judiciary that we have now, because you have to know your audience, right? And as students, you're learning, and as lawyers, we know that when you advocate, you always have to consider your audience. And so I think we're in an era now where we have to think about what are the arguments that are going to be persuasive now, not just what were the arguments that were persuasive in the 70s when we started with the disparate impact theory. What were the arguments that were persuasive even 10 years ago? Those arguments may not be as persuasive now. And so I've been doing a lot of thinking about this in terms of sort of what is resonating now and how is that hurting, but then also how can we use that language and those arguments to further the project of equity in housing and undoing the decades of racial segregation and discriminatory policy that is de jure, as Richard Rothstein just explained, as opposed to just perpetuating the status quo. And the beautiful thing about disparate impact theory is that it recognizes that neutral policy is perpetuating segregation and it's perpetuating inequity. And I think that's why we do have to care about it and think about how we can preserve it. It remains important, even if it hasn't lived up to its potential. We know it hasn't. It remains important because it has the potential, it always has the potential, to help address more structural inequalities and address patterns that were created historically, right, that persist. And so I think we got a great introduction to disparate impact through Richard Rothstein's presentation. He did me a great favor by kind of setting it up, because it can be a little bit wonky when you talk about it. But, it is a theory aimed not just what's in someone's mind, and I think Professor Kelly really helped us by saying, we get stuck on the idea of intent as necessarily just being motivation. It can be more capacious, as Professor Kelly said. It can include other things, and maybe we need to spend more time on that as well. But disparate impact doesn't have to care about what's in someone's mind. It doesn't have to care about that. It can just focus on consequences. Because the idea is that it's the functional equivalent. If the consequence is exclusion, then that's the functional equivalent of someone intending to exclude, right? It's important to remember that disparate impact doesn't require less evidence. Some people have come to think about it as like the plan B. Oh, well, if I can't prove intent, I can just try to use an effects theory. It's not that easy. It's not necessarily easy. It doesn't require less evidence. It just requires different evidence, right? You have to point to a neutral policy or practice that is having a disproportionate effect on a protected group. It's not enough to point to a disparity all by itself. It's not enough to point to, oh, look at this housing complex. It's all white. Right, bottom line result. That's not enough for disparate impact. You have to point to what in his or her policy choices and practices that are falling more heavily or burdening more heavily a protected group. And so it is not necessarily easier. It just requires a different evidentiary analysis. And so I do think we need to protect it. We need to preserve it. What are some of the tools and some of the language that the court is now, that the judiciary at large, including the Supreme Court, is more captivated by? Well, we're seeing a number of things. One is, and many of these things have been around a long time. This isn't necessarily new, but I think some things that we have to think about. The tortification of civil rights law. The ship has sailed. Many scholars have very effectively made a case that we shouldn't think of civil rights law in the exact same way as we think of any tort, but the ship has sailed. The Supreme Court is going to assume that Congress legislates against a background of tort rules, right? And so when there's a question, when it's unclear how to interpret the Fair Housing Act, the court's going to lean on background tort principles, right? And so that's just what we're dealing with. We know that textualism has become much more salient than purpose in how a court will interpret any statute, including the Fair Housing Act. And so how can textualism be used more effectively by those who would like to see civil rights law actually help bring about equity in housing and neighborhoods? We know that the court will no longer be bound by Chevron in terms of being required to defer to agencies' interpretations of statutes, right? the courts are competent to read statutes by themselves, right? Under the Loper-Bright decision, thank you very much. Courts can do that themselves. They can adopt find them persuasive, but they won't be required or bound to defer to an agency interpretation under the Chevron doctrine, which no longer exists. Also, we see the court, and you can see this in some of Gorsuch's, even in the Bostock case, this idea which actually interpreted sex to include sexual orientation and gender identity discrimination, which was also not expected. But even in that case, you see Justice Gorsuch taking care to ensure that everyone understood that the civil rights laws were not concerned with group-based remedies. They were concerned with violations of law against individuals. And so you can see him really kind of making sure, laying some groundwork maybe, and just making sure that everyone was understanding that the current court, or the majority of the current court, is not thinking about law as addressing group-based harm. And I think that's really important for us as we think about how to make our arguments, right? The other thing that we know we're dealing with is essentially a very extreme vision of race blindness. And so we're in this position of we're trying to address racial inequity without, I can't even finish that, right? It's this very bizarre context for our work where we've got laws that address racial discrimination. How can you ensure you're in compliance with a law that addresses race discrimination unless you think about race? We're not quite there. I don't think we're quite there in terms of we can't even think about it, but I think I'm a professor. I don't think there are two sides to fair housing. I think there's not. I still have a heart of an advocate here. And what I would say is that we need to think about where the court's going with this, right? How far is the court willing to go in terms of assuming racialized thinking and actions out of existence without really ever eliminating racial hierarchies? Like, how far is the court willing to go? And we can't assume that the court is not going to go as far as trying to hold or trying to argue or trying to establish that we can't think about racial inequality as we try to create more fairness in our communities. I think we have to be a couple of steps ahead on that and theorize it and work it out. And I'm still working on that myself. And so I'll try to give a few examples without getting too far into the weeds on this. On the issue of tortification, right? We know causation is a concept in torts that we saw emerge in the Inclusive Communities decision, where the court says, create some safeguards to protect against certain uses of disparate impact that might be an abuse of the theory or that might not be what the Fair Housing Act was intended to accomplish. And so one of the things that the court instructed was Justice Kennedy in the Inclusive Communities decision that recognized disparate impact theory was to say, we need to make sure that litigants establish a robust causality. Well, for many of us, this was nothing new, right? We knew that you had to identify a policy that caused a disparate impact. But this was something that the court made clear, and I think was sort of doing in a proactive way to beat back some of the opponents of disparate impact theory that said disparate impact will push towards quotas. If you can just point to someone's racial disparities, then in order to avoid liability, they're just going to adopt quotas to make sure that they have racial balance in their housing, and we need to avoid it. And so Justice Kennedy said, no, we have robust causality. You have to show that something the defendant did caused the disparity. So the question has become, well, how are courts going to interpret this causality? Are they going to interpret it as they always have, which is, sure, you point to a policy that the defendant adopted or practiced, and you show how it's falling more harshly on a protected group. That's how disparate impact's always worked. That's how it's worked in the cases that the Supreme Court cited when it upheld disparate impact. This isn't anything really novel or new. Well, some circuits are reading causality in a new way, and it's my circuit, the Fifth Circuit. And so some people might say, well, we don't have to worry about that. We're in Connecticut. Or we're in fill in the blank, right? We're not in the Fifth Circuit, therefore we don't even have to think about what they're doing. Well, I would push back on that. I would say that that some of the judges in the Fifth Circuit are reflecting thinking outside, just more broadly, and they're reflecting some of what is contested about the disparate impact theory. It's just that they have the numbers to write some of these ideas into their decisions that maybe other circuits don't. And again, I think sometimes we make this mistake of, well, we don't have to worry about this right now, but that doesn't mean that maybe a lower court judge somewhere else, and I've seen this. I've seen some judges in other jurisdictions start kind of trying out some of these ideas. Maybe they'll stick. And so I do think we have to pay attention to the ideas. And so what am I talking about? Well, in the Fifth Circuit, there was a case by the same organization that brought the Inclusive Communities Project in Dallas. And they had a case challenging a voucher ban that worked essentially in a way that banned vouchers. There was an advertisement that no vouchers would be accepted in an all-white area where the same companies were accepting vouchers in neighborhoods of color, right? And so this wasn't even a situation where you had different landlords with different policies. It was like some of the same companies who were having different policies depending. So talk about perpetuating segregation, right? We're going to accept the housing assistance that is disproportionately being used by people of color. We're going to accept it in places where people of color already live, and we're going to reject it in places where they have not historically had access, right? This is classic perpetuation of segregation. And so Inclusive Communities brought a suit, and the lower court dismissed it at the pleading stage on the grounds that they did not satisfy the robust causality requirement. Why? Because the plaintiff couldn't show, and this was actually the view that was also adopted at the Fifth Circuit, the plaintiff couldn't show that the defendant caused people of color to be in the predominant group that used vouchers. So the causation requirement morphed into something that was impossible to show and prove. The plaintiff had to show that the defendant caused the reason for the impact or the effect, not just the effect itself, right? So how could a plaintiff ever show that a defendant was responsible for someone's income level or amount of resources available to use housing or eligibility for a housing program? It would be impossible, right? And so, yet, this is what I mean by no permanent victories, right? Yes, we have disparate impact, but what are the standards that courts are going to use in requiring plaintiffs to plead the necessary elements of that disparate impact claim? So what we did, and just sort of an example of, well, how do you use this approach to push back on this theory of causation? The Fair Housing Action Center in New Orleans brought a subsequent case that was going to be still operating with this kind of Fifth Circuit impossible standard to challenge a blanket ban on criminal records, right? And so neutral policy, blanket ban on criminal records, not covered by the that criminal record status is not a protected category under the Fair Housing Act, but many people have challenged a blanket ban on criminal records as falling more heavily on people of color, given our not so distant history and criminal justice rates of, like, the sentencing rates of arrest, et cetera. And so the concern was that the Fifth Circuit was going to require the plaintiffs to show that the defendants at the apartment caused people of color to be disproportionately incarcerated, which would have been impossible, right? And so one of the arguments that some of us made was that let's look at the text of the Fair Housing Act. And this is just one example. The text of the Fair Housing Act creates an exemption for certain types of criminal record history, right? And this exemption was written into the Act in 1988. And it didn't exempt all criminal history. It exempted distribution and manufacturing, which means you can't, the Fair Housing Act will not cover, will not address convictions for certain kinds of criminal distribution and manufacturing. Well, why would Congress have done that, right? Unless it was concerned treatment, an intent theory wouldn't have addressed criminal history, right? Because it's not covered. So it would only make sense to exempt certain types of criminal conviction history if there was a disparate impact theory available. Would be used to say that criminal record exclusion is falling more heavily on a protected group. And depending on your locality and depending on your statistics, that protected group would be most likely people of color. And so what we argued using a textualist analysis was when Congress decided to exempt certain criminal convictions, it decided not to exempt others, which means from a textual standpoint, challenges under the disparate impact theory to criminal record bans were challenges that Congress permitted just through the text of the act. And in fact, in the Inclusive Communities decision, Justice Kennedy goes even farther and says, let me explain how this exemption would work. Certain statistics might show that people of color are more likely, or that there's a correlation between rates of incarceration or arrest or sentencing length and race and national origin. And so it wouldn't have made sense for Congress to include this exemption unless it saw a disparate impact claim possibly being available. And so they decided, we're not going to allow that for manufacturing. We're not going to allow that for drug distribution. But presumably they chose not to exempt any other kind of criminal conviction, right? And so even Justice Kennedy writes that into his opinion. And so in the Fifth Circuit, we pointed, because this blanket ban case that I'm talking about did go all the way up to the Fifth Circuit. We argued that if we use your standard on causation, we will be running afoul of the text of the Fair Housing Act and Supreme Court precedent. And so that's an example. That in that case, the court, it seemed to me, wanted to avoid the disparate impact issue altogether, and they dismissed on standing, which wasn't argued by any party and wasn't briefed. But I digress. So that's an example of using language, using arguments that may be more likely to resonate. Use what you have to try to know your audience and, I guess, maybe slightly disorient the judge because you're using arguments that are most resonate, but perhaps can help your client and perhaps keep the theory alive. The other, just a couple of more ideas on this, and I think we'll open up to questions. On the idea of group-based remedies, right? On the idea of the court reminding us that the civil rights laws are not there to address group harm, they're just there to protect individuals. Well, I think if you think about exclusion like bans on multifamily housing, bans on vouchers, bans on any criminal record, no matter how old it is, no matter whether it's violent or nonviolent, whether it has anything to do with what kind of a tenant you would be today, that certainly sounds like a group-based, a categorical group-based restriction and exclusion. What the disparate impact theory is trying to do is require housing providers to engage in a more individualized assessment, right? And so if what the court is saying is we need to focus more on individuals and less on group-based categories, then I would say the disparate impact theory does just that, because it is there to say, why are we excluding any and all voucher holders from an entire community? Or why are we excluding multifamily housing from an entire jurisdiction? It certainly sounds like a very broad type of exclusion. Why aren't we asking whether these individuals would make good neighbors, or creating more of an individualized assessment? So that's one idea. Or on the issue of the court being resistant to kind of any consideration of race, or just how we talk about it and how we think a more just society and communities. I think what is different about housing as compared to higher education and maybe employment is inclusion is not a zero-sum game. Right? Creating more access and choice in the housing market doesn't have to necessarily take away a housing opportunity from anyone else. And I think that makes housing a little different than some other contexts where this has been quite contested. And maybe that's an opportunity for us to address this, I think, really highly charged moment of how much can we think and use race in addressing some of our issues, our most pressing issues of wealth inequality and so on. I think using housing to address some of those issues could be an opportunity for us to make advancements there, or to at least preserve our ability to talk about race and think about race in moving us forward, because of the fact that it's not a zero-sum game. It doesn't have to be, and it isn't. And so we need to think about how to be more proactive and use some of the tools, some of the language that we know are more salient now with the current judiciary, to preserve what we have, and I dare say even advance beyond where we are now, because we've never really fully utilized the disparate impact theory or the Fair Housing Act to its full potential. So I'll leave it there.
Thank you very much. So I think we have about a little over 10 minutes for some questions. And if you have a question for the panel, raise your hand and we will get you a microphone.
First of all, thank you. We heard so much about fully vindicating the protections secured by the Fair Housing Act, and even better protections that may be needed on top of the existing act. But these protections mean nothing if the protections of the act are not enforced. So do you think that meaningful enforcement of the act is a problem, and what recommendations do you have to better enforce the act at both the local and national levels? I think we heard strands of this in the discussions about sexual harassment, curating arguments that resonate with the appropriate audience, and even addressing or not addressing group-based harm. But if you could please speak to meaningful enforcement on the ground more specifically, I'd be grateful. Thank you.
So I think enforcement with the Fair Housing Act has always, from the very beginning, been a sticking point and an issue with the Act's kind of failure to develop to its full potential. The role of local fair housing organizations and national fair housing groups to bring testing cases and be the ones out in front pushing the litigation has been extremely important in both detecting violations and identifying violations, and then also bringing them forward. But it's not the best state of affairs. In many other civil rights laws, the victims themselves are in a pretty good position to identify that what's happening to them is wrong, and to be able to have counsel to represent them, with fee shifting and things like that. And in housing, it's just so much harder because, an individual who's being, mistreated in housing may not even realize it, and even if they are, may have no idea what you're supposed to do with it. I think we've got such a more robust sense in our just popular discourse that, employment discrimination we know is wrong, and we know that there's agencies you can complain to and you can file lawsuits and get money if you prevail. And I think we just don't have that same sense in the fair housing world among the broader community. I certainly know that many of the women, virtually all of the women that I ever worked with or that I studied, literally did not know that there was a statute that could protect them. They didn't even know how to describe what was happening to them as something that was against the law. And so I commend DOJ and HUD for trying to bring some broader awareness to sexual harassment in their initiative that they started in 2019. But there's so much, they have so much to do. I really think that we need to involve, we need a change in how we think about a lot of these things, And I analogized it to sort of the domestic violence situation where 30, 40 years ago, that wasn't viewed as the same kind of criminal activity that's against the law, that can be addressed by law as it is today. But that took a lot of grassroots mobilizing from activists that had to go prosecutor's office by prosecutor's office and state house by state house to get laws changed and to get enforcement protocols put in place at the local level. So that's just one example of one kind of Fair Housing Act violation that I think needs, more concrete attention. So many of the other ones that involve things like steering or citing of affordable housing and things like that, those are even, we can pull those back to even more of the 10,000-foot level that are hard to detect, hard to even identify and describe as being a harm, and then hard to get courts to realize also violate the law. So I think we have a lot of work to do. We have a lot to work with. We do have a statute that has good stuff in it. It just hasn't been used as effectively as it could be. Some of those are just structural. Some of those are just the people who are the direct victims of most of this are the ones least in a position to recognize what's happening to them and to push a case forward. And so that requires advocates and scholars and a whole infrastructure to try to bring that along. And that's where I think we are. I don't know, do you have?
I think that listening this morning to Richard Rothstein talk about local advocacy and local movements and organizing, it's not enough for lawyers to have clever arguments, right? As much as we, need to do that work, we need to be talking about this across disciplines and talking about it in our communities in a way that helps us all think differently about it. Because even though it's not a zero-sum game, there's still a sense of entitlement to exclusively segregated communities. We know that. And so how do we have the conversations we need to have, and how do we mobilize or support communities in mobilizing so that we can think differently at the local level?
So I'll just briefly add this. So, I transitioned from fair housing litigation, right? Some of my peers from the Connecticut Fair Housing Center are here, who I, worked with in the trenches with respect to advocacy. But I transitioned to academia for a reason, and part of that is because I appreciate the opportunity in this space to kind of think from this theoretical paradigm to think about our ideas around social change, and therefore to be able to develop a blueprint with respect to what legal advocacy could look like. And so on one level, I actually have an article that's forthcoming that builds off some of the insights with respect to the Bostock case, because that's a surprising outcome. And what's interesting there is that they do anchor it in the textualist approach. And so it does suggest that perhaps we can have success if we maneuver in a way that tailors our arguments to the audience. And so I've kind of done some of that thinking, and it also touches upon the Lincoln property case and how we can kind of think that through from finding some text-based ways to put some parameters around this duty of care that I was talking about a bit earlier. Happy to elaborate on that a bit more, but I know that we're running low on time. So just look for it. That's my plug, I suppose. The second piece, though, is that, we need to be mindful also with the idea that, legal victories are, on one level elusive, and then when procured are vulnerable to degradation, right? And so we need to be thinking about, in my assessment, movement lawyering paradigms, right? Where we think about how the role of lawyers can be with respect to broader social movements and change. And so I could talk a little bit more. I teach state and local with respect to kind of some of those dynamics, but I'll leave my thoughts there for now, and happy to continue conversations throughout the day.
Do we have time for one more question?
I think this is maybe perhaps a little more related to Professor Oliveri's comment earlier about the unregulation of the private rental market, and sort of thinking through a public policy lens of, that is an issue, and it affects not just sexual harassment cases. I think that can lead, especially in situations where private landlords come predominantly perhaps from a specific subsect of the population, wealthy landowners, perhaps a predominantly white group in certain areas. How can we look towards assessing that issue proactively? Do we see a pathway to potentially regulating landlords? Do we see a way to perhaps from the grassroots lens, like organizing tenants more uniformly across jurisdictions? I know tenants unions haven't always been, able to launch off in many jurisdictions, but they do show some, at least a possibility for individual tenants to be able to access non-landlord resources. So I guess I'm curious to see what everybody's perspectives are on thinking on that public policy side of addressing these issues.
Sure, and I mean, I think that's an incredibly important point that, I looked at it through the lens of sexual harassment, but there's many other aspects in which this can be a problem, that we've got a huge percentage of this extremely important resource being distributed by people who are basically not regulated. I mean, they would say they are, but anybody that's ever worked in this space knows the structure gets inspected to make sure the roof isn't going to fall, and that's mostly about it. Like there's very few other things, because it's a local government thing, and so every municipality will do it differently, and some may do it more. Some may have more robust regulatory apparatuses, but many of them don't have much of anything. And I think that is an extremely important place to put in, to at least suggest reforms. It will be a difficult thing because it will have to be, there's thousands and thousands of them all over the country, and each would have to sign on. And the landlord, the property owners have a lot of political clout. I know in my own community of Columbia, Missouri, the Apartment Owners Association calls the shots when it comes to how well they're regulated. So I think that it's a tricky order. I wonder if there's a way that HUD can pull a lever, because they're giving community development block grants to these communities, and perhaps they could insert some sort of requirement that there be some level of oversight or a complaint mechanism within the local community that the tenants have to be made aware of, whether they're receiving low-income housing vouchers or not, just that all landlords have to provide that kind of information, and that the city has to run something like that, just to help with awareness and to provide some sort of oversight. But it's a really difficult question. I mean, you're absolutely right.
I guess we are out of time. Well, thank you very much for your thoughtful questions, and please join me in thanking our panelists one last time for their presentations.